3CR would like to acknowledge the Kulin Nations, true owners, caretakers and custodians of the land from which we broadcast. Welcome to 3CR Raising Our Voices, 8:55 a.m. Today we're talking about the NDIS from the advocate's point of view. I'm Bronwyn Trickett from AMIDA, an advocate in the NDAP program, which is the National Disability Advocacy Program. And at AMIDA we also have the NDIS Appeals Advocacy Program. I'd like to introduce our guests. We have Rachael from RIAC.
Hi, Bronwyn.
Ange from AMIDA.
Hi, Bronwyn.
And Judy from AMIDA.
Hi, Bronwyn.
Rachael, you've been working in the Geelong office at RIAC.
That's right, yeah.
And Geelong was the first to roll out for the NDIS, the first area. So that was a couple of years before other parts of Melbourne and Australia were rolling out. Can the rest of the country expect any improvement since the time that you've been doing this work?
Yeah, if we're talking in the context of NDIS appeals, then I think there definitely has been some improvements since it first launched in Geelong over 5 years ago. And it's best to talk about the positives first. So,
for sure,
there's definitely been improvements in the time frames that they respond to the appeals. So in the beginning, it was just a team in Geelong that was managing everything, and I don't think they realised how big it was going to get so quickly.
Right.
So one of the best things that they've done is to implement a more nationalised team that's called the AAT Applications and Decisions Division, and they've tended to bring more expertise into the area and have tended to look into things in a more timely manner. There's a lot of earlier resolutions that we're seeing happen. The process can be quite lengthy and traumatising for participants to go through. So I think they've become a lot more mindful of that. There's still a lot of room for improvement, but that's one of the positives. I know that in the beginning we saw a lot of unusual things happening, like confidentiality clauses. When tribunal matters would be settled, the NDIS lawyers would force settlement on the condition that there'd be confidentiality clauses so that people wouldn't be able to talk about what decisions were made. And I haven't seen one of those for at least a year. I'm not sure if anyone else has had a similar thing, but that must have been something that was, for the first few years, was happening, which was quite scary. And I don't even think there's legal backing behind that. So that was a bit troubling. But now they don't do that anymore.
Okay. RIAC, I suppose we should introduce the organisation name without the acronym. Can you tell me, what does RIAC stand for?
Yeah, it's the Rights Information Advocacy Centre. So it can be quite a mouthful.
Yes. And you've got branches in Geelong and also other parts of Victoria?
Yeah, so there's Geelong, there's Shepparton, Bendigo, Horsham and Mildura.
Right.
Yeah.
And can you give us a view of the problems with transport that you've seen?
Yep, sure. I think one of the big issues with NDIS and transport comes down to the operational guidelines. The NDIA have a range of operational guidelines which help to promote consistency in their decision making, which is a really good thing, because I think a lot of the unfairness that people see in the NDIS comes from inconsistency and people thinking that, they're not getting the same as what other people are getting. So that generates feelings of unfairness. So the operational guidelines are good to be able to promote a consistent approach. And the transport operational guidelines, there's there's a statement there that talks about the guidelines being a contribution to someone's transport costs, and there's then 3 levels of transport funding which are applied based on the person's need. But the NDIA seem to often run a line that it is just a contribution. The operational guideline does say that there is possible to be funding outside of those guidelines if you meet exceptional circumstances. But in practice, that often you don't see a lot of people getting plans, just going through the normal review process without a level 1, level 2 or level 3 transport funding. So the issue with appeals is that particularly at the AAT level, the AAT seems to pay very little regard to those transport levels in the operational guidelines. So they sort of almost just push straight past them and apply the reasonable and necessary tests to someone's transport needs. So it's seen as a reasonable and necessary support at an AAT level rather than an operational guidelines level 1, 2 or 3. So,
okay.
Yeah, and there's been quite a few cases at the AAT level where this approach, where the guidelines are almost disregarded. Yeah, so there's been quite a few cases where that has happened.
Also, to explain what the AAT is, the Administrative Appeals Tribunal.
Yep.
So for our listeners who might not be familiar with that term, so there's an appeal can go to the NDIA for an internal review.
Yep.
And then the AAT, it will be reviewed externally. Is that correct?
Yeah, that's what happens. So if you have a decision, so if you've got a plan where you're not happy and you'd like to have it appealed, the NDIA needs to have the opportunity to review that decision internally first, which is called an internal review or a Section 100 review. So that needs to happen first before you can then take it to the next level of the Administrative Appeal Tribunal, which is an outside review, an external review. Yes. So the AAT will step into the shoes of the NDIA, so to speak, and make a decision based on the evidence before them. So it's not a court, but it's sometimes described as like a court, but it's not a court.
Okay. Moving on to Judy. It's important to put in complaints. I think this is something that you are saying this is a really important topic to discuss.
Yes, I think that part of the way of dealing with the issues that many people have at the NDIS is not simply through the appeal mechanism that they have, but also not putting in complaints, and there's different levels of complaints. So you start off with a complaint to the NDIA itself, but then quite often people have the experience that there's no response from that process. The other, or the next level of complaint mechanism is to the Commonwealth Ombudsman, which is an administrative law sort of process where, as an independent agency, that they review executive government action. And even if you put in a complaint to the Commonwealth Ombudsman about any aspect of the NDIA, the Commonwealth Ombudsman does not necessarily take on and intervene and, negotiate or contact the NDIA on your behalf, although they may. But in every case, they will record the issue and compile data that goes back to the higher levels of government, that's the Commonwealth Government, to, in annual reports, although they haven't been
the Commonwealth Ombudsman reports
released recently.
Okay.
But it does give a mechanism for, a central collection of data issues for. So I encourage, participants themselves to put in complaints to the Commonwealth Ombudsman, or I often do it on their behalf, or even on behalf of advocates, because any issue can be submitted that way. But I think it's important for the issues to be identified so that hopefully, if the NDIA doesn't fix them themselves internally, that pressure can be brought to bear through the Commonwealth Government.
Yes. You're listening to Raising Our Voices on 3CR. In the studio, we're talking about NDIS appeals. Steve Grainger from Villamanta, we've got Steve on the line. Are you there, Steve?
Hello, how are you?
Good, thank you. How are you today?
Yeah, not too bad at all, thanks.
Thank you for joining us.
Oh, you're most welcome.
Can you tell us, Steve, something that is close to your heart that listeners might like to hear from you about?
Yeah, of course. There's probably a number of matters that are sort of quite close to my heart at the moment, but probably one that's fairly topical for me is people with what they're terming psychosocial disability, trying to access the scheme. One of the things that I'm finding, and I think others are finding too, is it's actually quite difficult for people with psychosocial disability to actually access the scheme. And what I mean by psychosocial, it covers things like depression, anxiety, post-traumatic stress disorder, and things of that nature. And one of the reasons, or some of the reasons that it's hard to access the scheme is that, firstly, it's difficult to prove that you've exhausted all avenues or all forms of treatment. So it's difficult to actually demonstrate that you've tried all forms of treatment, and nothing further can be done to alleviate your condition. And another thing is they'll often say that medication will stabilise your condition, and although it won't cure it, and so you still have your disability, an antidepressant or something of that nature will stabilise your condition, and so therefore you're able to live a reasonable life, even though you still have the condition, and also, and I guess sort of allied with that, you're still able to function, if you like. So you're not impaired, or so you can do things like drive, and you still have a sort of a level of functional capacity, and so therefore you essentially don't meet the disability requirements that come under Section 2024 of the NDIS Act, whereas in fact, as probably most of us know, if you have a psychosocial disability, many of those sorts of things don't really apply, because if you have a disability like depression, the medication doesn't truly work, and many of us know that it might work for a while, and then its effects wear off after a while, and you'll have to go onto another medication, or it'll work in a way, but it may turn you into a zombie sort of for a while.
Yes, or conditions can be episodic as well, not always the same.
Exactly. Yes, exactly, and so it's often very very hard and very frustrating to come up with a level of sort of proofs, if you like, to convince the agency, and should it go to the Administrative Appeals Tribunal, to convince the tribunal that the condition that the person has is in fact lifelong, and they're going to need to be on the scheme for the rest of their life, and medication is not going to be the medication alone is not going to be the answer to their disability. So as I said at the start, there are quite a number of, sort of things that are, of interest to me in relation to this scheme. But it just so happens that I've got a number of, Villamanta has a number of clients that are experiencing difficulties accessing the scheme because they have psychosocial disability and that particular type of disability is somewhat awkward to get past the gatekeeper, for want of a better term.
Yes.
Yeah.
Thank you, Steve.
You're welcome. Thank you.
Some topics that are commonly coming up through the processes are also plan reviews, internal reviews. We've touched on transport and psychosocial. There's also consent with the NDIA, light touch reviews. There's quite a lot of planners hierarchy is another one. Medical reports is another one. Lived experience statements, jurisdiction questions at the AAT. I'd just like to ask all of our guests today if you'd like to talk about any of these topics or something different.
Well, one of the big things that we're still seeing is with internal reviews, the NDIA doesn't have a legislated timeframe that they have to respond to these reviews. It's just a reasonable timeframe. So we've often seen matters sitting with the NDIA in review for over a year. So a big movement has been to try and push it forward to the Administrative Appeals Tribunal without a decision from the NDIA. And this has been a big question for the tribunal, whether they can actually hear these kind of matters. Recently the tribunal is reluctant to hear these matters, but what we've seen, quite a good trend, is that once it gets to that point, the NDIA will make a decision. So they'll look at that review and make a decision on that review. And
can I just interrupt there? There's also talk that the AAT is waiting on a decision of concerning that jurisdictional question, which I think is why they've put a lot of them on hold, if you like. And it's frustrating in another way that we're on hold waiting for this decision to come out.
Yeah, it certainly is. Yeah. So one of the positives that we've seen is that if the internal review goes, if you apply to the tribunal before a decision's been made, the NDIA makes a decision on that internal review, but the legal team also advises them on that decision, we've found.
Okay.
And that's been a quite positive to get that advice, so then there might not be a need to go to the tribunal once you get that internal review. But it's certainly a shame that it has to get to that point, and we're looking forward to that decision being made.
Decisions being made in a more timely manner.
Yeah, and getting some guidance from the tribunal about whether matters can be brought to the tribunal without a decision from the NDIA. Yeah.
And there's also, on that topic, the Tune report that has been commissioned, authorised, whatever, from the Commonwealth Government to look into certain issues with the NDIS Act, one of which is timeliness and I have no idea whether the AAT is waiting for that report to be decided, but at the moment it's at discussion paper stage, so it's going to be some months away.
Yeah.
Yeah. If I might, I'd like to just touch briefly on the light touch reviews. We've had a few clients sort of mentioned to us just recently that they've put in Section 100 review, so an internal review to the NDIS, and the NDIS have come back to them and said if they would be willing to drop their Section 100 review, the agency would be willing to do a light touch review. And of course, the problem with that is that if they drop their Section 100 review and the light touch review turns out to be not positive, they may well, the 90-day period may well have elapsed, and they may well have lost their opportunity to have an internal review, and that may well also lead to them losing their opportunity to take the matter to the AAT. So they may well they may well find themselves having lost, their opportunities to have a proper internal review and a proper external review. And we've accordingly advised clients that, to say to the agency that yes, they'll go for a light touch review, but they're not going to give up their right to, to still have the Section 100. The Section 100 review, so they won't drop the Section 100 review. They'll go for the light touch, sure. But
can I interrupt there, Steve? Because I agree entirely with what you're saying. I think the issue with individuals who don't have an advocate is that they don't fully understand that process, and the NDIA certainly don't explain to them their potential loss of rights. So, yeah.
And that's and that's been very much the case, and it's been a concern of ours because we've only sort of got onto it because we've had a few people ring us and say, look, the agencies said would you do a light touch review and drop your Section 100 review? And it's been sort of 2 or 3 people who rang us. Phoned us up and asked, what the implications are that we've become aware of, and it's made us wonder how many people are out there.
Likewise, I'm not sure that they're actually asking advocates if they want to.
No.
When someone's got an advocate, so it's an unknown problem.
Yeah, I think the issue is too that there's that sometimes the people working for the agency or the local area coordinators, they don't actually know what the consequences are either of withdrawing that Section 100 and doing a plan review or a light touch review instead. And that just goes along with the theme of the NDIA and LACs, is that lots of issues are happening on the ground that's causing the reviews to occur in the first place. Lack of training, lack of awareness, misinformation, inconsistencies, and it's a big issue.
Yeah, look, I agree entirely, and I think it's probably, a case of, that, they are not approaching people that have advocates of any sort. They are approaching people that are, without an advocate, and and therefore, probably in a more vulnerable position than obviously.
And desperate for results too. They're desperate for that plan change.
I think it's important to highlight that there's a review of the NDIS Act and there's consultations occurring at the moment until the 30th of October. So on the DSS website, I believe it is, there's
Department of Social Services.
You can do lots of different ways that you can do submissions. So you can do an online survey, you can attend a forum, and you can do there's a short version survey and a long version survey, or you can write in a submission. So I think that's important to have a say.
Has anyone or does anyone want to mention the planner hierarchy issue? In that often when a person goes and gets their new or goes and has their plan reviewed, the person that they speak to who helps them make up their new plan, and then they go away reasonably happy with what they think is their new plan, only to find out a little later when they receive their new plan in the post that it bears a little or no resemblance to what they thought it was going to be, because the person who actually sat across the desk from them isn't the final decision maker.
And I think that's coming from a position of the NDIA's or the NDIS principle that it's an individualised system, and they want to be able to speak to each person and have their plan tailored exactly to their needs. But then from the back end, if you like, from the agency's point of view, They can't have all of those people that have actually spoken to the individuals making the plans because of issues of consistency. Maybe saying the NDIA's answer here, but I can see, where the problem comes from, but it really creates a lot of issues for the individual because they just don't understand how they can have had so much support by the planner at the meeting that they have and then end up with something that is just so contrary. We've had quite a few where, this has raised real issues and they just fall back on, it wasn't my decision, it was taken out of my hands because it goes up the hierarchy and someone else makes the decision.
Yeah, absolutely.
You're listening to Raising Our Voices on 3CR. In the studio, we're talking about NDIS appeals. From AMIDA's point of view, AMIDA stands for Action for More Independence and Dignity in Accommodation. We've been very interested in what's happening with specialist disability accommodation, or what's called SDA. And we've noticed that quite a lot of people that were on the waiting list on the DSR, so the register for supports, may have been eligible for housing, that they're now finding themselves they're not eligible for SDA or housing through the NDIS system. And we've got some information from the Summer Foundation that released a report in April saying that over 90,000 Australians with a disability in the NDIS are currently in inappropriate or unaffordable housing. And this includes over 6,000 people, younger people in aged care facilities. The NDIS is designed to bridge their housing gap for around 12,000 people with disability. But we're looking at about 80,000 people with a disability are currently not in affordable housing. And that's, looking to the state, I suppose, for support for housing. And we already know that there are around 200,000 people on the public waiting lists for social housing across public or social housing across the country. So this is quite a alarming matter that we've been looking into. Does anybody have any thoughts they want to discuss about SDA?
Those numbers in particular, I haven't sort of spent a great deal of time. I mean, I'm aware of those. The problem, one of the problems with SDA and people thinking that they can access supported disability accommodation is that the NDIS is structured that only 6% of people on the NDIS will be able to get SDA. And I mean, you can imagine the 7th, 8th, 9th and 10th % might either be eligible or think that they're eligible, and yet just because of the actuarial structure of the finances of the NDIA, whether they are or not, if they're sort of lower down the list, they're not going to get onto it, which contributes to those sort of statistics.
We can talk for hours about this topic, but unfortunately we've run out of time. Thanks to our guests for coming onto the show today, for NDIS appeals advocates.
Can I just add one final thing before we finish? If people are looking for an advocate, a good place to start is the website disabilityadvocacyfinder.dss.gov.au, which will list advocates all around Australia.
Thank you very much. Thanks to everyone.
Thank you.
Thanks.
Bye.
Bye. And you've been listening to Raising Our Voices, 8:55 a.m. Stay tuned for our next show, Completare Bailable, coming up.
You've been listening to a 3CR podcast, produced in the studios of independent community radio station 3CR in Melbourne, Australia. For more information, go to allthews.3cr.org.au.